Good morning to all of you. My name is
Christian, you're muted.
I promise you, I'm a way better lawyer than I am technician. And thank you, Valeria, for letting me know that I've been muted. So let me start again. I'm Christian Zeller. I'll be your host for today's webinar, the new USCIS adjustment of status memorandum. And we are broadcasting from our Philadelphia office today. And by way of introduction, here's Jane Schoner. Jane has merged her very, very successful practice with our practice a number of years ago, and we are very pleased that she has remained with us of counsel. With us is also Valeria Villaverde, who just saved me. And Valeria is our practice director in our Philadelphia office, and she limits her practice to our family-based clients and all of our religious worker visas. And finally, Tim Zeller. Tim Zeller manages all of our business immigration in our Philadelphia office and also our federal court litigation. So before we get going, there are a few housekeeping issues. You're muted, and please stay this way. And please also keep your videos off. Otherwise, Valeria will turn your video off. It interferes with the presentation if you turn it on. Um, if you have any questions, please drop them in the chat. We will answer them throughout the presentation or at the end, whichever is going to work better on this. We'll see how that works. Uh, Most importantly, today, this is only general information and not legal advice. You all know that immigration law has been a moving target. Things change on a daily basis. So while everything we tell you today is true today, it may not be true tomorrow. So if you are acting or if you plan on acting on anything we tell you today, please do a check with us first. This is, of course, also a general presentation. Your individual facts are very, very different. And if you have any specific questions about your specific case, then please reach out to your MGC attorney at your respective MGC office. And we are recording this presentation, and so these slides will be shared with the recording afterwards. Now, here's what we're going to cover today. First, what happened? The memo in plain English. Secondly, very, very important, the law has not changed. Third, we'll explain the two pathways to a green card, adjustment of status versus consular processing. Fourth, we'll talk about discretion, the whole heart of that memo. What does it really mean and how does discretion work? Then we'll talk about the factors, all your positive equities versus the adverse factors. And since we're lawyers, we got to talk a little bit about case law, and we'll talk about matter of Orion and matter of Marin, which are very, very important in this context. And finally, number 7, what does all of this mean for you? Whether you're a business immigration client or whether you are a family immigration client. And finally, what's the plan? And we'll answer your question. So here we go. What happened? You already all know that on May 21st, the USCIS has published this policy memorandum, which was titled Adjustment of Status. And adjustment of status apparently now is a matter of discretion, which it always was, and a matter of administrative grace. So this is basically a message of the government to its USCIS officers to treat in-country green card filings as an extraordinary remedy, and that really consular processing is the typical, classic, and regular way to go. And in conjunction with that memo, the next thing that happened was a very, very loud press release, and the memo's text, fortunately, is far narrower. But the press release really caused all this panic, and that's the entire press jumped on that, and this is where we find ourselves today. So here we're trying to debunk all of that. Valeria, we know that the law hasn't changed. Help us through that. What happened?
Thank you, Christian. Thank you for that introduction. Hi, everyone. As Christian said, my name is Valeria. I'm the practice director here in our Philly office. And obviously, this policy memo caused a lot of concerns for everyone. So I want to start, as Christian mentioning, talking about how the law has not changed. So yes, this policy memo was released. Yes, there was that conference, but there is no law change. So everything has stayed the same in the sense of the regulations that control the filings of adjustment of status, both family and employment based. And so we are continuing in our practice to still file these adjustment applications. Everybody should be, right? Because the law has not changed. What has shifted is the way that officers are making their decisions about these applications. So filing is still allowed under the law, but the way that the officers are actually deciding, reviewing the applications is what has been instructed wise with the policy memo, not necessarily shifted.
So, Valeria, there are two roads to that green card, and how does that work now?
Yeah, so there's two ways to obtain permanent residency, that green card. You can do it in the US, which was what we call an adjustment of status, or you can do it through the Department of State, which is abroad, and that's called consular processing. So this memo was all about adjustment of status, which is the road from inside the United States. So that's when you are eligible because of the way you entered, somebody is petitioning for you, and then you file the adjustment. Consular processing is outside. And now talking about the myth versus fact. I think the myth is there's a lot of myth, there's a lot of false information out there. And I think that's obviously because of that press conference that was released after the policy memo. But there was fear that you could no longer adjust status, which is not true, right? We still know we can adjust status. There was fear that we had to leave the United States to obtain permanent residency. That's not true. If you're still eligible under the law, you can still seek adjustment of status here in the United States. People were thinking that you were automatically going to be denied if you had a pending adjustment of status application. That's not true either. And people thought approval was not possible. Again, not true. We've seen the approvals already come in since the policy memo was released. So what has actually changed or really been instructed to the officers since the policy memo was released? Well, that AOS is discretionary, and we're going to talk a little bit more about what discretionary means. It directs officers to review submissions based off the totality of the circumstances, right? So everything being submitted. It asks applicants to affirmatively show positive equities, and we're going to talk about what those positive equities can be. And realistically, what this all means is probably higher scrutiny on these applications that are pending. So really, we're probably going to get a lot more RFEs or NOIDs. An RFE is a request for evidence, and a NOID is a notice of intent to deny. And I think that's really what's going to come out of this. Really more questions from the officers versus necessarily stopping the processing altogether.
So, Tim, it's all about discretion. What does that really mean for our clients?
Yeah. And so, discretion is obviously, is a very simple manner. It's up to the officer to decide. And they're now weighing two sets of factors, right? They're going to look at positive factors and they're going to look at negative factors. But what they use in terms of language is this phrase administrative grace. And it's not something new that just came with this policy memo. It's been around for decades. It has always been the language used around adjustment of status. And so, just because you're eligible for adjustment of status doesn't mean you're going to get approved. And that was always true. But now the main difference is they want to more heavily weigh these positive and negative factors. Discretion doesn't mean that this is a coin flip. It doesn't mean that it can just be an arbitrary or inconsistent no, or that it depends on something that the officer imagines. But it's also not something that is an easy to measure or what we would call a bright line test, where we can say you've checked these three boxes and you're definitely going to be fine. So it is going to take a little bit of extra work, obviously, now to paint the right picture and show that you're not only eligible, but truly that you're worthy of the discretionary decision being in your favor, and ultimately getting that approval.
So Tim, what are those positive factors that we should be looking at?
So there are several, and I don't think that this is necessarily an exhaustive list, right? But one of the strongest and one that's mentioned in agency kind of case law is the strength of family and community ties, and it's not just about having those ties and them existing. You know, mom and dad being here is great, cousins being here is great, but it's also the closeness. It's demonstrating this kind of closeness to community. And so that's part of what we want to document, not just that there's an address here, but that there's a relationship. And obviously, if that closeness is the basis of your petition, well, then they're going to really take a close look at, is this a real marriage, or how close are you to your spouse? It's very important now that everything is documented instead of just assumed. Things like a long-term, residence in the United States, whether that been through non-immigrant visas, right? That you were here lawfully for several years, a law-abiding citizen, especially if you've been here since a young age, legally. Your parents came on a non-immigrant, you've been their dependent for 10, 15 years, and now you're getting married and you've been a law-abiding citizen. Well, that's a strong factor in your favor for why you shouldn't have to go back to an embassy to apply for this green card. And something that, we'll talk about in a second, obviously, is there are going to be negative factors. Maybe you had a mistake that you made in the past that resulted in some sort of criminal conviction or record. They're also interested in demonstrating rehabilitation and cooperation with the justice system, and not just doing the bare minimum of what was asked for you in those sorts of cases, but what happened afterwards? What did you do for the community? Did you do additional community service, volunteering? How have you reformed yourself? And so if you've made a mistake in the past, that's going to be a negative factor. But it's more important than ever to show who you've become after that, to maybe get that now in the positive column, right? And outweigh that negative factor. And so the one thing that's really important to keep in mind with the positive factors and why they're important to demonstrate is that in the memo, they very clearly say that the absence of adverse factors on its own doesn't demonstrate that you have positive or outstanding factors in your favor. So again, we need to load the side on your side of the scale, to be favorable, so that we're making these compelling stories in all of these applications that get filed.
So Tim, what are the adverse factors then, and how are we going to deal with those?
Yeah, and so you can probably imagine, you can probably already know things that are adverse. It's relatively common sense. Obviously, immigration violations and overstays, those are going to be threatening. We never want to say fatal. We never want to throw in the towel. And each situation is different. But obviously, with this administration and this memo specifically, you can imagine that immigration violations, specifically overstays, are going to be highly suspect in the analysis. Of course, things like fraud or false testimony when previously dealing with USCIS or any government agency is not going to be great for your application. It's going to be horrible. And there are certain things that you might not be able to dig your way out of. But the important thing is to be transparent so that you know what you're dealing with. I really want to stress the importance of documenting everything and having a clean record. Failure to depart, in my opinion, is going to be one of those major red flags that comes up in the review of an application. Because what are they basically saying? He didn't comply or she didn't comply with the laws, and now they're trying to adjust status. They're really not trying to leave. That's exactly who they want to send to an embassy, because that overstay is going to be difficult to overcome at the embassy. You might be subject to a bar. And the objective, I think, unsurprisingly, to this administration is to make it not just harder, but to sometimes make you ineligible for years or forever, to get you to depart. So all things that you want to keep in mind. There are certain things in the memo that are very problematic. The memo directs officers to look at country-specific facts, and this is where the administration can really defer to itself and say, well, you're from such and such country. They don't do a great job down there, screening the information. We have a lot of visa fraud that comes from there. So now you already have the deck stacked against you just by virtue of your home country. This has been going on since the beginning of the administration, but of course, if you're seen as endorsing or promoting anti-American views, terrorist organizations, the definition of which continues to expand, you need to be very careful with those social media posts and how they can be interpreted, because with discretion, they can look at certain things, and that can be a big negative factor. And all they need to do is find a few compelling no's, and it's over. And so, again, criminal history, of course, that's going to be a negative factor, but consider, of course, what you can do afterwards to make yourself look like a better candidate. And if you're looking at these adverse factors and you have a couple of them, this is definitely when you want to consult with an attorney, because it's easy to assume, well, maybe I could build up my own case. I have a lot of positive factors and there's nothing wrong. Even then, you should talk to an attorney. But if you have a lot of negative factors, or even just a couple, then you're really at risk if this application isn't handled the correct way.
Well, Tim, and since you have to prove your positive factors, even if you don't have any negative factors, it seems to me that applying for adjustment of status itself is considered a negative factor, because that causes me to have to prove everything.
It's certainly the narrative that they're putting out there with the policy, but I think it's important also to highlight for the negative factors that if you're planning ahead, right, and you kind of have a blank slate with your immigration history so far, a lot of this is avoidable. You can plan ahead, and you just don't play it loose and fast with your immigration status, because again, they're going to try to catch you for minor mistakes, and they're going to try to catch you for big ones. So building that positive record and avoiding any of these pitfalls, if you have a clean record, is obviously a big priority.
And so, of course, none of that is new. If we start looking at the case law, you can see that this case, matter of arrival, was decided in 1970. So the USCIS didn't just cook this up last week. So Jane, can you help us understand what matter arrival is about and why it is so important for us? You're muted, Jane. It's you and me who can't do it.
You and I are same generation. I just want to add one thing, a kind of a good thing, what I think, onto Tim's presentation. The policy manual does set guardrails on the exercise of discretion. So if I were sitting out in the audience, the first question I would drop into the chat box is, what's the effect of the announcement, the policy memo, the policy manual, the regs, the INA, the BIA decisions? How do they stack up? But what the policy manual says, and the policy manual is really the centralized controlling source of the immigration policy. So it starts out as a policy memo. It might get to the policy manual. It's harder to make it a regulation. There's no way this is going to get to be a regulation. But those guardrails are that discretion cannot be exercised arbitrarily, inconsistently. And here's the big one. It can't be based on bias and assumptions. And that entire memo is based on an assumption that Congress intended adjustment of status to be extraordinary relief, which just is not true. So pre-1952, everyone consular processed. I'm sure that when Christians started practicing, we did a ton of consular processing because there were no bars. It was really simple. It was easy. And Section 245 was extended and amended at least 20 times since 1952. And not once did Congress try to limit it and make it extraordinary relief. and play with these adverse factors. So, I mean, I just think there's some good things in here. Good lawyering is going to make good law. Bad lawyering is going to make bad law. So there's some ways that you want to do this. You know, they talked about building the affirmative equities record. But the other thing is address each adverse factor. Don't leave it for the officer to determine the weight that goes to that factor. So there's a lot of things that lawyers can do. And please, please, please don't look at ChatGPT or try to read BIA cases and say, oh, this guy had unauthorized employment and his adjustment was granted. Don't do that. Every single case is different, and every single case is going to have a different package. And we're working hard on the cases that have already been filed to really get to the point where we can go into that interview and we can really knock down anything that that officer is going to say. So that's my point on the adverse factors. But matter of Arrai, a 1970 board case, it was a precedent decision. It was involving unauthorized employment, but it established the framework regarding how discretion is going to be exercised under 245. When adverse factors are present, they don't, interestingly enough, they don't discuss the adverse factors. It may be necessary to offset those adverse factors. It has always been like that. We have always done it like that. So it's nothing, nothing really new. But what's kind of cool in this decision is when the record is clean, generally favorable factors like family ties, length of residence, they're going to be considered as enough to merit a favorable exercise of discretion. So matter of Arrai is going to be super, super important. They don't talk in Arrai about what negative, serious negative factors are, but I think you guys can figure that out. You know how serious these adverse factors are. I mean, we can kind of rank them based on the policy memo and just based on our experience in dealing with USCIS, where we see inconsistent outcomes, unpredictable outcomes, because the cases aren't prepared correctly. The memo.
And matter of Array is still good law, Jane, right?
It
I
is
mean,
very
that's
good
still
law.
law.
It is good law, and we will use it every time. And Arrai and the memo don't align because it contradicts the proposition favoring an applicant with a clean record. So that's why I said, my first question would be, ooh, what takes precedent here? Is it a BIA decision? Is it a policy manual decision? Those are things that we know, but you might want to know that too if you're presenting your case or we're presenting your case for you. There's another case, matter of Marin. I don't like this case as much, but a lot of people do. It was a 212C case, which, again, 212C is not.
Only we remember, yeah.
Yeah, that's unfortunate. So in this one, the guy 212C means he was in deportation proceedings at the time. So it wasn't an adjustment. It was a waiver. And the other thing that you should know is I can, off the top of my head, think of at least 13 applications where we argue discretion. So again, not something that we're like, wow, how do we do this? We're used to it. We've done it. We've done it for years. But in this one, in Marin, the guy pled guilty to selling cocaine. It was a felony. He was sentenced to, I think, 1 year to life. He was single, childless, had no family, employed sporadically. And in that case, they balanced the factors. What I took away from Marin is it's a good balancing test, where you put the good, the bad, and you balance against it. Scary because these USCIS officers exercising discretion, they're not going to be consistent. There's language in Marin that as the negative factors grow, the more serious they are, and you're going to have to present these equities that are really, really, really going to overcome these horrible things. But there's one more
But Jane,
case.
if you put that into context, the Array, which is still good law, and the Marin factors, which is the balance that we use, how does that compare to the policy memo?
It's directly contradictory to the policy memo, and the BIA trumps the policy memo because the BIA is law. But there's one more case I want to talk about, which we didn't put on the slides, which is Loper Bright. And Loper Bright overruled, and I'm not trying to get into the weeds, but I know there's some lawyers out there. They overruled a longstanding principle that courts would defer to agencies in the reasonable interpretation of a statute. But Loper Bright is relevant because we're really, what we're doing in that memo, or not we, they are interpreting 245, section 245, which is the adjustment section, and its purpose, which is that it is a matter of administrative grace and extraordinary remedy, and it's not. So the courts are now bound by that policy memo. We're going to see lots of cool litigation. We'll probably be a part of it. And we're also going to see it already. There's an article in the Washington Post today that USCIS is walking back the memo for businesses. And you're going to see a lot of changes from today. So what you see today is not necessarily what you're going to see 3 weeks from now, or even a
But
month.
you would agree that the USCIS walking back their language has about as much weight as the memo itself. It's all on
Exactly.
that same level. Yes.
Exactly. That's all I got.
So, Tim and Val, here we got business immigration and family-based immigration. What does all of this, what we just spoke about, really mean for our clients in particular cases?
Tim, you want to go first or me?
Sure, I guess we'll go from left to right. So I'll talk very briefly about the employment side of things. And look, you're in a good position. If you have an H-1B or an L-1 specifically, you're in a really great position. Because the memo itself kind of draws this dividing line. It acknowledges that this depart and go consular process expectation has, frankly, built-in exceptions. And that includes the non-immigrant categories with dual intent. And the L1 and the H1B are those non-immigrant categories. And so, if you're on an L, if you're on an H, if you've gone through the perm process, you're going to have a strong case, I think, that adjustment will still work for you. Of course, all the other factors that we talked about are still going to come into play. But you also have some added benefits kind of baked in, right? You have probably been here if you've gone through a perm process for several years. You've built those ties to the community. You have a good relationship with a U.S. employer, right, that demonstrates these ties. And so you're just in a much stronger position. That's not to say that it's guaranteed. They've gone out of their way to say that it isn't. But that is to say that we have stronger arguments in our favor, specifically for L's and H's. But that cuts both ways. If you're, on a non-immigrant category that specifically has this intent carved in a way that you're not supposed to have immigrant intent, well, now that's gotten a lot harder because the law specifically says that you ought to go home in consular process. And again, it's going to be case by case to see what's possible. And of course, how you're adjusting matters too. There might be a different argument if you're going through a perm on one of those non-immigrant intent visas versus a family-based, marriage-based case, right? So it's always going to depend, but you're in your strongest position, I think, with an L, an H, and a perm case, or of course a marriage case in that sense. And there's a lot to think about on the employment side because it's about your intent at entry and that there's a following expectation to depart. And so the standard route for a lot of individuals has been F1, OPT, H1B. Well, now you have a complicated history because really with the F1s, they've made it clear that they expect you to depart. And OPT is next on the chopping block, but we'll need a different webinar for that when that happens. So you want to be mindful of how did I come here? What does the entire record say? And what has happened since, right? So again, weighing those positive and negative factors is going to be extremely important. But again, I think on the employment side, you're going to have an easier time with that dual intent visa. Once you leave that dual intent category, you need to start making, a strong, favorable case, and really we'll have to get into the weeds on that.
So Valeria, we have business people coming to the country, on visitors visas, and then a couple of months later they decide to open a business, and apparently that's not a problem. But if I come as a visitor and a couple of months later I decide, I'm going to marry, and in the INA, love at first sight does not exist. How do we deal with that? Is that a problem?
Yeah, so my family-based cases, those are definitely going to be the harder ones under this new policy memo, right? Because the big things they're looking at, and Tim mentioned this too with the employment side, but they're really looking at what your status was when you entered, and what your intent was, right? And that's what they're trying to filter with that is preconceived intent. They're trying to make sure that you didn't come to this country already with the intent to stay here permanently if you were entering on one of these non-immigrant visas, right? And so it's really going to come down to those factors, those positive and negative factors that we keep repeating when we're filing these adjustment of status applications. And they're really going to look harder at the family-based cases because employment, as Tim has mentioned, you really have a lot working on your side, right, of what you came to do and how you ended up staying, especially those dual intent and the perms. But the family base are definitely going to be looked at with higher levels of scrutiny. And I think we're going to get a lot more requests for evidence. So it's really going to be a case by case basis of really balancing those different positive and negative factors and what evidence we can provide to USCIS when we submit these applications. But yeah, it's something that's definitely going to have a high level of analysis when we're initiating these cases because these are really the ones that immigration is going to come hard on.
So, Jane and Tim, on the employment side, versus the family side, we can actually keep an underlying status while we apply for something else. Does any of that make any sense, or should we abandon that? Or what are we telling our clients on this?
Well, we never want to abandon the status if we don't have to. Historically, I think it's always been a case by case basis. Sometimes you can't extend that L further. But now that we have a little bit less certainty on the outcomes of an adjustment, it certainly makes sense to maintain the underlying status, in my opinion.
I would agree, and I would also add, don't do anything to harm yourself. Don't when you're working on OPT, don't take a job as a aerobics instructor. Be smart.
Yeah, and I think it's
Unless you
important to
study
note
sports management.
Yeah.
if the dual intent takes away a negative factor, right? If we're talking about weighing this on the scales of favorability, it takes away the negative factor of, oh, the intent aspect is a negative, but it doesn't add a positive. What does add a positive is on the green card route. If you have an approved I-140 in, whether that's NIW, EB1, or through PERM, that is actually looking like a positive factor and not just an eligibility factor. So the path has some benefits to it, but keep in mind that dual intent on its own is not a positive. It's just not weighing against you.
Okay, so that's great on the employment-based side, but Valeria and Jane on the family-based side, a dual intent, if you so will, is not a good idea, is it? What are we telling our clients to make sure they remain on the right side on the fence on that?
So I think realistically with family-based cases, it's going to be a big timing issue. So when did you enter the country and how quickly did you get married or how quickly did you file? Because that's really going to be the analysis, I think, for preconceived intent, which is going to be a huge factor when officers are making decisions with their discretionary power on these cases. So again, I keep repeating this, but weighing those factors and making sure you have a clean strategy of when we're filing and what we're providing to immigration on the analysis basis is going to be key here. Because obviously the dual intent is not going to help us with these family-based cases. So it's going to be a lot of weighing those factors. What do you think, Jane?
Yeah, I agree. I think I think the memo targets these people. These are the
Yeah.
people that he doesn't want here. And when someone comes into the office and they've been here for 20 years, then the question becomes, how do you create that equity package? It's difficult. I had a consult yesterday. The woman is here for over a year, so we have issues like she's from one of the 76 countries or whatever where she can't consular process. She's only been here a year. She's working without authorization. I said, pay taxes. She does go to church. I said, teach Sunday school, do something. I mean, create that equity package because the family-based applicants, I think, are under attack here.
I think that you
I,
bring up a good point on being proactive on how you're preparing yourselves while you're in the United States before actually filing.
and that segues right into our next slide. And I'm inviting the whole panel to maybe discuss that. And let's talk about that record, build the record. What are we telling our clients what they should do, what they should start collecting in order whenever that adjustment of status might happen, what should we have in our quiver?
I like to start with choose the right path because, which is I know is number 4 here. But some people just can't consular process. They're going to subject themselves to the 10-year bar. Um, it's just not, it just won't work. Those people, we really have to step in and go in with a really, really strong application and really advocate for the clients in the interview. There is no way that a client is going to be able to go into that interview and argue and advocate for themselves with the officer who, when they walk in the door, is thinking, I'm going to deny your case.
Right. I mean, that's almost like the blind leading the blind. So how, how do we protect our status then? I mean, for many people, that might already be too late. Moving forward, of course, I can do whatever it takes, to make sure that I'm in compliance.
Right. One of the things with the protect your status, what worries me is the adjudication times on the H-1B and companies not realizing that that employment authorization only extends for 240 days. And even though we remind them, and even though we tell them premium processing is available, it's very expensive, they may say, you know what, no one's going to know if they're working beyond that 240-day period. And that could come back and bite them like a year later, or bite not the company necessarily, but the foreign worker when they're trying to adjust status.
Have you not also experienced, Jane Tim and Val, at USCIS interviews that officers now claw back to your very original entry to the United States and they roll up the entire immigration history?
Yeah, I'm glad you brought that up. So really, right now in these interviews, they are going as far back as your initial DS-160 application that you got for your non-immigrant visa to enter the United States. They will compare that application to the current application and go line by line to see if you told the truth, if you lied to get that non-immigrant visa. And then touching upon now the policy memo, they're asking a certain line of questioning during these interviews to ask you why you didn't go back to your country to consular process and what you're still doing here. And maintaining status in that line of questioning. So yeah, they're looking at everything, including these new questions that we didn't usually see so often in these interviews.
Okay. So before we wrap it all up, let's go to some of the questions. One of our clients is asking, CP is the other option to adjustment of status, correct? And if applying for CP, can the applicant stay in the United States until the embassy schedules the interview overseas?
Depends.
Yeah.
Well, thank you for the lawyer's answer.
Maybe. If they have a non-immigrant status that allows them to stay, they certainly can stay. But
so the key is to be here legally. You
yeah,
can't wait in the US unauthorized and then go consular process.
potentially you can. I mean, the people that file the 601As,
I'll say that, yeah.
who entered EWE, yeah, Val, you have a million of those that.
Yeah, so if you have a pending I-601A or an approved I-601A and you've already started the consular processing, then technically you'd probably wait here. If you're on a non-immigrant visa that hasn't expired yet, you'd probably wait here. So an annoying answer, but it depends on your situation.
Okay, what's the failure to depart? Deportation question mark? I
this is,
suppose.
it
You know,
could
if
be, right? But it's also just a matter of if your status ends on June 6th, I'd get out on June 5th. That's pretty much, unless you're extending your status, you're changing your status. A lot of folks on the employment side are used to having this 60-day grace period. That is also something that has historically and in the law always been discretion. And, so it's better to file those extensions before that time. I haven't seen them not exercise that discretion. But if you don't have an extension, if you want to play the game of let's figure it out, maybe I can use these 60 days, I wouldn't. I would preserve the record.
here's a very interesting question. What about the countries put on hold for consular applications? Is that a good reason to justify adjustment of status if there's no other option?
I would imagine that the whole point, or not the whole point, but part of the strategic thinking is to force individuals back to those countries where they can't consular process by default in order to limit the amount of green cards being issued. I doubt. I think it's the opposite. I think they specifically say in the memo that they'll look at these specific country conditions, which is often what they have cited now in these bars and these holds to stop the processing at the consulate. So I actually think it's the opposite. It's not going to be a good argument for adjustment at all. It's probably going to be a negative factor.
But
Okay.
I would use it on the contrary
Me
to a
too.
different argument. For a family-based case, I would quote family ties, right? If you have to go back to a country who has a travel ban, who knows how long you're going to be outside and separated, maybe potentially from your kids, from your spouse. So I would argue the opposite, that it would possibly help the adjustment of status in regards to the family ties that I mentioned.
Not an interview that you would want to attend without a lawyer.
Yes.
The next question, then those that already have submitted and are waiting for final action should update our cases to include more and more of the equities?
Absolutely.
Yeah.
Would you wait for an RFE or would you update now?
It depends. I would say if it's an online filing, USCIS allows you to update and provide updated evidence online automatically. So if your case has been more recent that you have that ability, I would say why not upload it already, right? If you don't have an online case because it's an older case that's been pending for a while, then I would obviously wait for the request for evidence, because if you just mail it to immigration, it's just going to get lost in the void. So depending on how the case was filed, but I would definitely, at least at this point, start collecting that evidence.
How about if someone already had an interview and the case has not been adjudicated yet? Let's say it's sitting at the local USCIS office. Would it be a good idea for us to update now, or would we, in this case, wait for an RFE?
I would wait for the RFE because I'm getting approvals in those situations. So sometimes you don't want to open that box if you don't have to, right? And add more time to the review process. But I think it's still case by case. Maybe if you have negative factors already, that are in the record, maybe you want to start getting out ahead of it.
Okay, the next question is, well, I'm in deportation proceedings. My I-130 was approved, and I have an ankle monitor. I'm sorry to hear that, but I'm not quite sure how we would answer that. It's not a question; it's a statement.
I think
Situation
we
for
missed one. I don't know if you saw that one, Christian. Could overstays be addressed by the exemption/allowance for immediate relative petitions?
go ahead.
Yeah, I think that argument again is based on those family ties, right? And possibly triggering one of the immigration bars, right? So why you need to adjust status versus leave the country. So I think it goes back to that balancing of factors. But yeah, I would definitely address the family ties in that type of situation as well.
Yeah,
Okay.
I think it's going to be interesting if they try to deny an immediate relative case based on either unauthorized employment or overstaying the visa, things that Congress has carved out in 245.
Right.
I want to see that happen.
Exactly.
Right. Is a married son, and I assume the son is married to a U.S. citizen, able to petition for parents who've been here on E-2 visas for 21 years?
This is an interesting one where you really have to get into the weeds because the E2, you specifically sign that statement either every 2 to 5 years saying that you intend to depart the United States when your E2 non-immigrant status ends. And they have very strict non-immigrant provisions. With that said, we've adjusted several E2 holders in the past, and this is where we go through the factors, right? Certainly being here for 21 years, one assumes you have pretty strong ties to family and community. And again, that's one of the strongest things being weighed. And you would have the aspect that it's a family-based sponsorship. So that again takes on additional weight. So it's one where we would have to get into the weeds, but I wouldn't automatically say no because of the E2 being how it is with the non-immigrant intent. But of course, that's going to be the biggest hurdle.
Someone is asking whether we're gonna get whether they're gonna get the files of this presentation. The answer is yes. We're gonna ship out the PowerPoint and the recording. Again, this is a good time for you all as a reminder, that this is not legal advice you're getting today. If you're acting on anything that you heard today, please check with us first before you do. Let me see what else we have on questions here. I have a question regarding the waiting time on marriage-based green card approvals. I apologize. I'm not going to finish reading the question. We cannot influence any of the waiting times. That's an individual question. Please reach out to your MGC attorney, and we'll be happy to deal with that. Let's see. My fiance will be traveling to the U.S. on an ESTA. Oh my. My fiance will be traveling to the US on an ESTA for 2 weeks to visit me and for us to get married. He will be returning to his home country after the wedding, and we will start the consular process from there. Should he proactively state that he is getting married in the US upon arrival?
Risky. It's risky. If I'm the CBP officer, I'm going to assume that if he is coming in to get married and he discloses that to me, I'm going to assume he's going to stay. I would be concerned about what happens at the port of entry but you don't want to misrepresent your intent at the port of entry either. So it's a really difficult question.
What if the CPP officer says, welcome to the US, have fun? Give you 90 days.
I'd go and have fun.
Yeah, I was about to say that. Enjoy yourself, get married.
Is the switch from a permanent resident to citizenship more complicated than it used to be?
The rules for filing haven't changed in that regard, but with kind of everything we're seeing with immigration right now, there's higher levels of scrutiny, I would say, on processing these applications. The interviews are I would say, a little more intense on what they're doing. And when you file for citizenship, I know this is a little off topic, but they'll go back and look at your whole immigration history. When I first started practicing, I saw these interviews tended to be a lot faster, and now they're going really in depth on, again, looking at those DS-160s, looking at the adjustment of status application, and then reviewing the N-400. So they're going through the whole immigration history when you're filing for citizenship.
I think though they issued that policy memo in August of 2025 about the good moral character. They're doing the exact same thing. They're making it a totality of the circumstance, the good moral character, same way as they're making, the adverse.
Intent.
Yeah. So it's interesting, but I haven't seen them apply it. I haven't, they said something about they're going into the neighborhoods to ask questions of neighbors. I haven't seen that happen.
I will say that I'm glad you brought that up, because the one thing I'm really strict with my clients before filing now with citizenship is on taxes. That's a huge thing they look at, and that goes to your good moral character. So being on top of, your taxes is huge. And I prefer not even to file with payment plans. If we can have everything squared away before filing, that would be better.
So you can't file a 601A without paying the CP fees. So can you file a 601A when in adjustment?
if you're adjusting, you wouldn't do the 601A because the 601A is to protect you from the immigration bars that you would trigger when you leave the country for consular processing.
Except the 601A is maybe based on a different issue, but then it's a entirely different issue. Yeah, if it's allowed.
That'd probably be a 601 then.
That would be a 601 and not a 601A. That's right. When you say equities, is it money related? I like debit cards, personal loans. Well, I guess, I mean, it matters how you manage your finances. I mean, if you owe taxes or if you haven't paid your credit card debt or if you owe money that you shouldn't be owing or where you should have paid something back, I'm sure that would be an adverse factor, wouldn't it?
It would be. The taxes specifically, that's always been something that's weighed in the discretionary analysis. Of course, when we're talking about equities, we mean factors as a whole. But of course, money matters.
It could bleed into the public charge area because if you can't pay your bills, you might not be able to support your spouse or I think in and of itself that, you have a bad credit rating isn't going to stop you, at least yet, from getting a green card.
In the case, if someone has an EB3, is it an EB3, and the case is a CP, can the applicant stay legally in the US under a valid E2 until the embassy schedules the interview?
There's if you're doing CP and you have the valid E2, then I don't see why you wouldn't be able to stay in the United States waiting for the interview.
You won't be able to port though. So you wouldn't be able to port to a new job or a new employer if you're going to consular process because you would need
That's
that
correct.
485 pending. So,
All right. Looks like we're running out of time here. Let's tie this all together. So we know that the law hasn't changed. INA 245 and adjustment of status is, of course, intact. I think we all agreed we're going to continue filing 485 applications. There's no questions about that. And the only thing that changed is USCIS's posture on discretion. And we probably be looking at more RFEs. But Jane brought up an interesting point, and that's the Loper Bright decision, where the Supreme Court now allows us or tells the courts that they are really in charge and that no one needs to pay any or give any deference to the USCIS, especially not a memorandum. A memorandum is not the law. So now we know that the positive equities, now matter more than ever. And, let's start documenting them up front. Maybe we'll even come up with a questionnaire for our clients or come up with a list just to trigger the collection of these positive equities because, it is human nature. You remember something today and in 2 weeks down the road, you don't know anymore. You want to collect it while you have it. And dual intent, of course, remains a big thing. So finally, if you have any questions, please reach out to your MGC attorney at your MGC office. We'll send out these slides, and we'll alert you if there is any new guidance or if there's anything else that happens. And finally, most importantly, please do not attend a USCIS interview without your attorney. If you don't hire us, then hire someone else. But go there with a lawyer. Advocacy in your case is now more important than ever. And with that, I'll turn it back to the panel if there are any final words, and otherwise we're done. Anybody else? Nobody else got anything for the road. So thank you all for dialing in, and we shall keep you posted, and we'll send out that file. Goodbye.
Thank you.